Hi everyone! As part of the report about Republic Act number 8371 or the Indigenous Peoples Rights Act of 1997, I will be discussing the NCIP or the National Commission on Indigenous Peoples, focusing on the mandate as stipulated under Section 39 and of course the powers and functions of the said agency as stipulated under Section 44 of RA number 8371. Likewise, I'll be also including two cases here. The case of LOLOY Unduran et al. As petitioners versus RAMON Aberasturi et al. As respondents. And another case about the case of the CMU and versus as the petitioners versus the Honorable Executive Secretary et al. So let's start. So as you can see, we have here the National Commission on Indigenous Peoples logo. And as for the mandate, as stipulated under Section 39, the NCIP shall protect and promote the interest and the well-being of the ICCs or the IPs with due regard to their beliefs, customs, traditions, and institutions. As for the power of the NCIP, as stipulated under Section 44 of RA 8371, the NCIP shall have the following powers and function. Number 1, to serve as the primary government agency through which the ICCs or the IPs can seek government assistance and as the medium through which such assistance may be extended. Number 2, to review and assess the conditions of IPs, including existing laws and policies pertinent thereto, and to propose relevant laws and policies to address their role in national development. Number 3, to formulate and implement policies, plans, programs, and projects for the economic, social, and cultural development of the ICCs or the IPs and to monitor the implementation thereof. Number 4, to request and engage the services and support of experts from other agencies of government or employ private experts and consultants as may be required in the pursuit of its objectives. Number 5, to issue certificate of ancestral land or the domain title. Number 6, subject to existing laws, the NCIP may enter into contracts, agreements, or arrangement with government or private agencies or entities as may be necessary to attain the objectives of this Republic Act and subject to the approval of the President to obtain loans from government lending institutions and other lending institutions to finance its programs. Number 7, to negotiate for funds and to accept grants, donations, gifts, and or properties in whatever form and from whatever source, local and international, subject to the approval of the President of the Philippines for the benefit of ICCs or the IPs and administer the same in accordance with the terms thereof, or in the absence of any condition, in such manner consistent with the interest of ICCs or IPs as well as existing laws. Number 8, to coordinate development programs and projects for the advancement of the IPs and to oversee the proper implementation thereof. Number 9, to convene periodic conventions or assemblies of IPs to review, assess, as well as to propose policies or plans. Number 10, to advise the President of the Philippines on all matters relating to the ICCs or IPs and to submit within 60 days after the close of each calendar year a report of its operations and achievements. Number 11, to submit to Congress appropriate legislative proposals intended to carry out the policies under this Act. Number 12, to prepare and submit the appropriate budget to the Office of the President. Number 13, to issue appropriate certification as a precondition to the grant of permit, lease, grant, or any other similar authority for the disposition, utilization, management, and appropriation by any private individual, corporate entity, or any government agency, corporation, or subdivision on any part or portion of the ancestral domain, taking into consideration the consensus approval of the ICCs or IPs concerned. And number 14, to decide all appeals from the decisions and acts of all the various offices within the Commission. Number 15, to promulgate the necessary rules and regulations for the implementation of this Act. Number 16, to exercise such other powers and functions as may be directed by the President of the Republic of the Philippines. And last, number 17, to represent the Philippine ICCs or IPs in all international conferences and conventions dealing with indigenous peoples and other related concerns. As for the case digest, the first case is about the case of LOLOY Unduran et al. As the petitioners versus RAMON Aberasturi et al. Respondents. GR number 181284, 20 October 2015. The facts of the case. This is a petition for review on certiorari assailing the decision of the Court of Appeals, which denied petitioners' motion for reconsideration. The petitioners, except for Mark Brazil and Nestor Macapayag, are members of the Miarayon Lapok Lirongan Talaindig Tribal Association, or the Talaindig tribe, who claim to have been living since birth on the land located at Barangay Miarayon, Talakag, Bukidnon, Mindanao, which they inherited from their forefathers. On the other hand, the respondents claim to be the lawful owners of and possessor of an unregistered parcel of agricultural land, which appears to be located within the ancestral domain of the Talaindig tribe. The respondents filed a petition for action reivindicatoria with prayer for the issuance of a temporary restraining order or preliminary prohibitory injunction with damages against petitioners before the RTC of Bukidnon. Petitioners Macapayag and Brazil filed their answer, alleging that respondents have no cause of action against them, while the rest of the petitioners filed their motion to dismiss, alleging that the RTC had no jurisdiction over the case. Petitions allege that with the advent of Republic Act No. 8371, otherwise known as the Indigenous Peoples Rights Act, or the IPRA, They, together with the rest of the tribe members, assisted the National Commission on Indigenous Peoples, or the NCIP, in the processing, validation, and delineation of their ancestral domain claim in May 2003. On July 25, 2003, Certificate of Ancestral Domain Title was issued by virtue of the NCIP and Bank Resolution number 0802003 to the Talaandig tribe over its ancestral domain in Talakag, Bukidnon, containing an area of 11,105 hectares. On October 30, 2003, President Gloria Macapagal Arroyo awarded the said CADT to the Talaandig tribe. As awardees of a CADT, petitioners argued that NCIP has exclusive and original jurisdiction over the case, as the subject matter concerns a dispute and controversy over an ancestral land or domain of indigenous cultural communities or the indigenous peoples. The NCIP, through Attorney Pimentel, filed a motion to refer the case to the Regional Hearing Office, National Commission on Indigenous Peoples, alleging that the RTC had no jurisdiction over the matter. On August 10, 2004, the RTC issued an order granting the motion to amend and supplement complaint and declared petitioner's motion to refer the case to the RHO NCIP and motion to dismiss moot and academic as a consequence of the grant of the said motion to amend and supplement complaint. On August 17, 2004, petitioners filed a manifestation praying for an ocular inspection of the disputed land to determine the last, actual, feasible, and contested status of the area. On August 25, 2004, petitioners filed another motion to refer the case to the RHO NCIP and motion to dismiss the amended complaint. On September 14, 2004, respondents filed their opposition and motion for judgment by default. On Feb 14, 2005, the RTC issued an order resolving all pending incidents before it. The motion to refer the case to the RHO NCIP and its manifestation for an ocular inspection are hereby denied for being bereft of merit. Further, defendants, or here in this case the petitioners, except Macapayag and Brazil, are hereby declared in default for their failure to file their answer to the amended complaint. As such, defendants Macapayag and Brazil be called for pre-trial and ex parte presentation of evidence as against the rest of defendants or the petitioners. Furthermore, the injunctive writ prayed for by the plaintiffs is hereby granted for being meritorious. Accordingly, defendants or the petitions are ordered to observe, maintain, and preserve the status quo subject of the action and or the relation between the parties in order to protect the rights of the plaintiffs while the case is pending in court and to cease and desist from performing any acts that in one way or another contravene the tenor of this order while awaiting final determination of the instant suit or until further orders of this court. Furthermore, to answer for whatever damage the defendants may sustain by reason of this injunction order, if the court should finally decide that plaintiffs or the respondents are not entitled to the relief if prayed for, plaintiffs are hereby directed to put up a bond in the amount of 100,000 pesos executed in favor of the party enjoined. Petitioners filed before the Court of Appeals a petition for certiorari and a prohibition with prayer for a preliminary injunction and issuance of a temporary restraining order. The CA rendered a decision affirming the RTC's order, which in turn denied the referral of the case to the NCIP. The CA ruled that the RTC correctly granted the amendment of the complaint and properly refused to refer the case to the RHO NCIP. The CA found that the subject matter of both complaints is well within the jurisdiction of the RTC. The CA noted that the only substantial amendment made was with regard to the nature of the action, which originally was one of acción reivindicatoria and then changed to one for damages. And except for some amendments as to petitioners' alleged violent acts and the prayer for declaration of their title to the subject property, the rest of the amended complaint was basically the same as the original one, including the reliefs prayed for by the respondents. And then the writ of preliminary injunction, the CA held that the RTC's assailed February 14, 2005 order is self-explanatory as to why the issuance of the same was proper considering the circumstances of the case. The CA denied petitioner's motion for reconsideration, hence this appeal on certiorari. The issue here is whether or not the RTC has no jurisdiction over the case. As for the ruling, the RTC has jurisdiction over the case. The Supreme Court applied the principle that to determine which court or body has jurisdiction is based on the allegations contained in the complaint of the plaintiff. Under Section 19 of BP 129 as amended, or the Judiciary Reorganization Act of 1980, the RTC shall exercise exclusive original jurisdiction in all civil actions in which the subject of the litigation is incapable of pecuniary estimation, and in all civil actions which involve title to, possession of, real property or any interest therein, where the assessed value of the property or interest therein exceeds 20,000 pesos, or in civil actions in Metro Manila where such assessed value exceeds 50,000 pesos. On the other hand, the NCP's jurisdiction is defined under Section 66 of the IPRA as follows. Section 66, Jurisdiction of the NCIP. The NCIP, through its regional offices, shall have jurisdiction over all claims and disputes involving rights of ICCs or the IPs, provided, however, that no such dispute shall be brought to the NCIP unless the parties have exhausted all remedies provided under their customary laws. For this purpose, a certification shall be issued by the Council of Elders or the leaders who participated in the attempt to settle the dispute that the same has not been resolved, which certification shall be a condition precedent to the filing of a petition with the NCIP. On the matter of the NCIP's jurisdiction and of procedures for enforcement of rights, NCIP Administrative Order No. 1, 1988, the Implementing Rules and Regulations of the IPRA, Rule 9, Section 1, states that the primacy of customary law. All conflicts related to the ancestral domain and lands involving ICCs or IPs, such as but not limited to the conflicting claims and boundary dispute, shall be resolved by the concerned parties through the application of customary laws in the area where the disputed ancestral domain or land is located. All conflicts related to the ancestral domain or lands where one of the parties is non-ICC or IP, or where the dispute could not be resolved through customary law, shall be heard and adjudicated in accordance with the rules on pleadings, practice, and procedure before the NCIP to be adopted hereafter. All the decisions of the NCIP may be brought on appeal by petition for review to the Court of Appeals within 15 days from receipt of the order or decision. A careful review of Section 66 shows that the NCIP shall have jurisdiction over claims and disputes involving rights of ICCs or IPs only when they arise between or among parties belonging to the same ICC or IP. This can be gathered from the qualifying provision that no such dispute shall be brought to the NCIP unless the parties have exhausted all remedies provided under their customary laws. For this purpose, a certification shall be issued by the Council of Elders or the leaders who participated in the attempt to settle the dispute that the same has not been resolved, which certification shall be a condition precedent to the filing of a petition with the NCIP. The qualifying provision requires two conditions before such disputes may be brought before the NCIP, namely, 1. Exhaustion of remedies under customary laws of the parties, and 2. Compliance with condition precedent through the said certification by the Council of Elders or the leaders. This is in recognition of the rights of ICCs or the IPs to use their own commonly accepted justice systems, conflict resolution institutions, peace-building processes or mechanisms, and other customary laws and practices within the respective communities, as may be comparable or rather compatible with the national legal system and with internationally recognized human rights. Therefore, pursuant to Section 66 of the IPRA, the NCIP shall have jurisdiction over claims and disputes involving rights of ICCs only when they arise between or among parties belonging to the same ICC or IP. In this case, while most of the petitions belong to Talaandig tribe, respondents do not belong to the same ICC or IP. Thus, even if the real issue here involves a dispute over land which appear to be located within the ancestral domain of the Talaandig tribe, it is not the NCIP, but the RTC, which shall have the power to hear, try, and decide this case. In conclusion, the petition is denied, and the Court of Appeals' decision and its resolution are affirmed. Okay, the second case is case of the Central Mindanao as petitioner versus the Honorable Executive Secretary et al. As respondents, GR number 184869, 21 September 2010. So facts of the case. The petitioner, Central Mindanao University, is a chartered educational institution owned and run by the state. In 1958, the President issued Presidential Proclamation number 476, reserving 3,401 hectares of lands of the public domain in Mosuan, Bukidnon, as school site for CMU. Eventually, CMU obtained title in its name over 3,080 hectares of those lands under original certificates of title. Meanwhile, the government distributed more than 300 hectares of the remaining untitled lands to several tribes belonging to the area's cultural communities. 45 years later, or on January 7, 2003, President Gloria Macapagal Arroyo issued Presidential Proclamation 310 that takes 670 hectares from CMU's registered lands for distribution to indigenous peoples and cultural communities in Barangay Musuan, Maramag, Bukidnon. CMU filed a petition for prohibition against respondents before the RTC of Malaybalay City, seeking to stop the implementation of Presidential Proclamation 310 and have it declared unconstitutional. The NCIP et al. Moved to dismiss the case on the ground of lack of jurisdiction of the Malaybalay RTC over the action, pointing out that since the act sought to be enjoined relates to an official act of the Executive Department done in Manila, jurisdiction lies with the Manila RTC. The Malaybalay RTC denied the motion, however, and proceeded to hear CMU's application for preliminary injunction. Meanwhile, the respondents, NCIP et al., moved for partial reconsideration of the RTC's order, denying their motion to dismiss. After hearing the preliminary injunction incident, the RTC issued a resolution granting NCIP et al.'s motion for partial reconsideration and dismissed CMU's action for lack of jurisdiction. Still, the RTC ruled that Presidential Proclamation Number 10 was constitutional, being a valid state act. The RTC said that the ultimate owner of the lands is the state, and that CMU merely held the same as in its behalf. The CMU filed a motion for reconsideration of the resolution, but the RTC denied the same. This prompted CMU to appeal the RTC's dismissal order to the CA Mindanao station. The CA dismissed CMU's appeal for lack of jurisdiction, ruling that CMU's recourse should have been a petition for review on certiorari filed directly with this court because it raised pure questions of law, bearing mainly on the constitutionality of Presidential Proclamation Number 310. CMU filed a motion for reconsideration of the CA's order of dismissal, but it denied the same, prompting CMU to file the present petition for review. Issue here is whether or not the Presidential Proclamation Number 301 is constitutional or not. The ruling is Section 9 of the Judiciary Organization Act of 1980 vests in the CA appellate jurisdiction over the final judgments or orders of the RTCs and quasi-judicial bodies. But where an appeal from the RTC raises purely questions of law, recourse should be by a petition for review on certiorari filed directly with the Supreme Court. So the CMU raised the issue whether the Presidential Proclamation 310 was constitutional. It did not matter that it was President Arroyo who, in this case, attempted by proclamation to appropriate the lands for distribution to indigenous peoples and cultural communities. As already stated, the lands by their character have become inalienable from the moment President Garcia dedicated them for CMU's use in scientific and technological research in the field of agriculture. They have ceased to be inalienable public lands. Besides, when Congress enacted the Indigenous Peoples Rights Act, IPRA, or Republic Act 837 in 1997, it provided in Section 56 that property rights within the ancestral domains already existing and or vested upon its effectivity shall be recognized and respected. In this case, ownership over the subject lands had been vested in CMU as early as 1958. Consequently, transferring the lands in 2003 to the indigenous peoples around the area is not in accord with the IPRA. Given the facts, the court grants the petition, sets aside the decision and resolution of the Court of Appeals, and declares Presidential Proclamation 310 as null and void for being contrary to law and public policy. So that ends my report. Ora elabora. I will continue, oh my God, to do all my actions for the love of you. Thank you very much.